That brings us to item 11, to adopt a resolution approving procedures for conducting a removal proceeding pursuant to section 412.5 of the San Mateo County Charter. Mr. Niblin.
Good morning, and thank you, Mr. President, and also good morning to members of the board. I appreciate the opportunity to present, for your consideration, the proposed procedures for a removal process for the Office of Sheriff, and this is, being brought to you pursuant to Section 412.5 of the San Mateo County Charter as it's been amended pursuant to recent action by the electorate. I think it's important to note that the county's work here is, frankly, the first time that procedures have ever been brought to a board for consideration, to my knowledge. There have been a couple of counties, as has been discussed in prior meetings, that have adopted charter provisions similar to the charter provisions that the county here has adopted. But to my knowledge, we've not seen in other counties a situation where procedures themselves have been brought and for your consideration. And that's what we're here to do today, is to look at procedures that would govern a process, assuming that process was ever initiated. So, as you know, so this, in my sense of things, this is somewhat historically significant, what you're being asked to look at. We brought an earlier version of these procedures to you as an informational item, as you'll recall, back on April 8th of 2025. And since that time, as we undertook to do, and we told you we would undertake to do, we've done outreach, including a meeting with counsel for the sheriff. And we've made some revisions, refinements, I guess I'd say. Some of them substantive, most of them process procedural. And, including, for example, as has been noted in the memorandum that accompanied this item for you, changing the pre-removal conference officer to the chief probation officer and providing for an alternate pre-removal conference officer or officers, allowing for optional pre-hearing and post-hearing legal briefing, and providing the hearing officer with authority to issue protective orders as may be necessary to protect the privacy of anybody participating in the hearings that might take place. And again, most of these were clarifying changes relating to how the discovery process would work, aside from the substantive things I noted. At a high level, these procedures were framed to address, the assertion from the sheriff that this process ought to be governed by the Police Officer Bill of Rights. Sometimes we call that POBAR. Some people call it POBRA. Various acronyms we've heard. So again, this process it is comprehensive, as you know, a lot of steps to it. But again, it was drafted with an eye toward the assertion that POBAR governs these procedures. Whether or not we agree with that, again, we were working very hard to track POBAR principles. As was the case in the last hearing that we had, Alfonso Estrada, or the last meeting we had at which this matter was discussed, Alfonso Estrada with the Hanson Bridget Law Firm, he's worked with the county to help develop these procedures, and he's available at this time to share some additional remarks. And I'm going to ask him to go ahead and add to anything that he believes is appropriate at this point.
Okay, John, thank you very much, and thank you to the board and for everyone for having me again. We've put in a lot of work into these removal procedures to make sure that they are compliant and that they are consistent with the principles of due process that are typically afforded these types of disciplinary or removal proceedings. The way that we've structured them permits various levels of independent analysis and review, which again is consistent with the principles of due process and what is typically required in these types of proceedings. The only changes we've really made since the last time we spoke were the three that John just outlined. And the discovery procedures that are called for in these proceedings are also very comprehensive. And again, everything that was done to create these procedures was done with an eye towards fundamental fairness to both the county and also to the sheriff in the event that the removal procedures are initiated. So with that said, I'm glad to answer any questions that folks might have. Last we spoke, folks had some questions then that we answered, and I'm more than happy to provide any insight if anybody has any additional questions.
Great, thank you very much. Are there any questions from board members?
Mr. President, I'd like for you to just run through exactly what will happen over the course of the process that we're putting in place.
I think I'll ask
Okay.
Mr. Estrada to go ahead and run us through that. You know,
Exactly.
from the point of initiation, assuming there were an initiation, to to the very end.
Yes. First, I'll start off by stating the board has not been presented with anything at this juncture, just to make that crystal clear. You are a clean slate as far as it relates to the analysis that these procedures have in mind. What will occur first is that a notice of intent to remove will be presented to the board for consideration. And upon their consideration and review, at that point, the removal procedures would go into effect and be initiated. At that point, it would require a 4/5 vote of the board to initiate removal based upon the notice of intent to remove and any and everything submitted with that notice of intent. Thereafter, that notice of intent would be served on the sheriff, and the sheriff thereafter would have an opportunity within 5 days to appear for a pre-removal conference. That pre-removal conference will occur with the county probation officer presiding over it. The sheriff will be permitted to present with her representatives and to offer any information in mitigation of the charges as outlined in the notice of intent, and also the bases for the removal. Thereafter, the probation officer will issue a recommendation back to the board, who will then consider that recommendation, and again, based upon that independent review by the probation officer, be able to assess that recommendation and make essentially another vote, and 4/5 is still required at that point. If the board does vote by 4/5, then the final notice of removal will be issued, which will trigger the remainder of the procedures, which will include the selection of a hearing officer, some limited discovery, which is clearly outlined in the procedures, and then the matter will be set for hearing to occur thereafter. The hope is to have it done within a 60-day period, including the close of discovery. Each side, the sheriff and the county, will get 5 days to present their case. We amended the procedures from the last time we spoke to permit pre-removal hearing written submission before the hearing, and then again after the hearing by both parties. At the conclusion of the removal hearing process, it will be submitted to the independent hearing officer. And again, this is another level of independent review of the grounds for removal. And then the hearing officer thereafter will issue their advisory opinion, a fully written opinion, to the board for consideration one last time. And then they will make essentially the final decision concerning removal after they get that advisory decision from the independent hearing officer. So again here, several independent checks, affording due process both to the sheriff and also to the county to make sure that there is fundamental fairness in these proceedings, and also in the ultimate decision that is rendered by the board after the various levels of review and appeal. So I hope that sufficiently answers your question, Supervisor, but please let me know if I missed anything.
Thank you, Mr. Estrada. Could you spell out more specifically what the notice of intent to remove will contain?
Absolutely. And the subject matter of it is based upon the Charter Section 412.5, which was enacted by the voters in about a month and a half ago. And there are specific causes for removal, and the notice of intent will entail, whether or not there was cause as defined under the ordinance or 412.5, and then all of the grounds and bases upon which those findings are made, including any documentation, which could also be detailed inside of the notice of intent, explaining how those provisions of the ordinance were violated. and why removal is ultimately necessary because of those violations.
And in that act, when the board considers that information, they will be acting in a quasi-judicial function. Is that correct?
They will be acting as the appointing authority. Okay, so because of the power that's been given to the board via the enactment of Section 412.5, they will be acting as the decision makers based upon the authority that's been given to the board by the will of the voters.
So is that a yes or no?
Uh, Judicial at that point, I would say no. It's an administrative decision you'll be making, subject to review and the appeal procedures that are outlined in the removal procedures we've created.
All right, thank you.
Are there any additional questions? John, I have a couple questions for you. Sorry, Supervisor Corso, go ahead.
Thank you. Just a quick one. I just want to name that I think folks have had, when the measure passed, I think some folks thought that it was done. And it's taken us some time to get here. Can you just talk a little bit about why it's taken some time and how that's been important in this process?
Thank you, Supervisor. I can appreciate the point you're making for sure. To answer your question, the charter language that was adopted by the electorate calls for the provision to the sheriff, if in fact a removal process is going to be initiated. It again requires that the sheriff be served with a written statement of alleged grounds for removal, and and it also calls for the sheriff having a reasonable opportunity to be heard regarding any explanation or defense. So that's kind of baked into the DNA of the charter amendment. Is this opportunity this notion of the fair opportunity to know what the bases are and what the grounds are that would constitute again, a reason for removal. And then again, the opportunity to be heard. The charter amendment also provides that the Board of Supervisors has the power to develop procedures by which a removal process would take place. And again, one of the things we've been wrestling with is kind of trying to hit the appropriate spot as we kind of weigh, the need for the desire for things to move in an expeditious way with ensuring that we afford an appropriate level of fairness and transparency and process in all of it. So that's, I think, that's what we've been wrestling with and trying again to find the sweet spot for all of this. And I recognize that that may not be completely, we won't address everybody's concerns, but that is why it's taken the time it has, because we want to make sure that we put in front of you and put in front of all interested parties, including the sheriff, a fair process.
Thank you. And then can our expert on Zoom explain the removal procedures in terms of whether they call for a public or private hearing and how that decision will be made?
Thank you, Supervisor. I will go ahead and ask Mr. Estrada to talk about that.
Certainly. The answer, first of all, is yes. There is provisions in the procedures that call for the hearing to be the removal hearing to be a public hearing by default. However, the sheriff, within 5 days of receipt of the notice of intent to remove, has the ability and option to request that it be a closed hearing. And that is just by operation of case law and certain statutes governing the confidentiality of peace officer personnel records. Again, the way that's been structured is it is for the removal hearing to be an open hearing, open to the public. However, in the interest, again, in complying with due process, the procedures also include that provision which do permit the sheriff, if she so chooses, to have it be a closed hearing.
Thank you.
Supervisor, I'm sorry, there was one other thing I neglected to say, actually, in response to your prior question. That was sort of the passage of time. And, the other thing that I think is important to note is that while the election on the charter amendment took place in March, there is actually a period of time that's required to certify election results. And it wasn't actually until mid-April that the charter amendment came into effect. So I think I probably should have noted that as well. That time we've certainly been using, but there was a certain amount of time, again, that was required for the certification of the election results.
Okay, last one.
No, take your time. Take your time.
The procedures call for any testifying to be done under oath, correct?
The testimony that takes place before the hearing officer will be done under oath. That's correct. I'll ask Mr. Estrada just to confirm that I have that right.
Yes, that's correct. Should in the event that there is a notice of intent to remove, it goes to the pre-removal conference, there's a recommendation made, and the board makes the final decision at that juncture for removal. The sheriff then can appeal to removal hearing, and that removal hearing will occur before the independent hearing officer, as I described previously. And any and all testimony that is taken in that proceeding will be taken under oath or affirmation. That is 100% a requirement.
May I correct one thing? Counsel, you said the final removal, it's actually a removal pending appeal, correct?
Correct, but as the procedures, you are correct.
Thank
There
you.
is a final decision that's made after the pre-removal conference, but that decision at that point by the board by 4/5 vote is subject to appeal by the sheriff to the removal hearing. So you are correct.
Right,
Supervisor Moore.
and to the supervisor's point, that's exactly how the matter is framed in the procedures themselves.
Thank you.
Yes.
Okay, I'll just close out by saying that I just want the public to understand that these removal procedures, if adopted, any testimony will be under oath, and if it's not public, it's not for the lack of will of this board. Thank you.
Thank you, Supervisor Corzo. Supervisor Gaucher.
Yeah, John, can you just remind the public what actually the public voted on earlier? Because when you're when you see residents and constituents, they're still unclear of what that vote actually meant.
Yes, Supervisor, thank you. Yeah, the vote itself was to approve, again, a charter amendment, section 412.5, which vests the Board of Supervisors with the authority to initiate a removal process and to actually move forward with removal if certain things are shown. The vote itself was not to remove the sheriff. I think maybe that was, maybe that's a piece of what, we're struggling with. The vote was to vest the Board of Supervisors with the authority to remove, subject to certain things being shown, proper cause, subject to the sheriff having the right to receive written notice of what that cause is and the opportunity to be heard with respect to all of it. So that's what was voted on, was to vest the Board of Supervisors with authority to take the action. It wasn't the ultimate action itself.
Thank you. And my last question is, I hear a lot of procedures. There's a lot that's going on. High level, what are we thinking about, or what are we looking at potentially on timing?
Thank you, Supervisor. Again, I'll ask Mr. Estrada to sort of work with me on the math. Assuming at the point at which there is an initiation of proceedings, if in fact proceedings are initiated, I think it's fair to say that the procedures as drafted now would contemplate something on the order of 4 to 5 months. But again, I'm going to ask Mr. Estrada to verify or validate or say something different if in fact I've got the numbers off a little bit.
That is about right. I would say it's closer to if the procedures are followed to a T. We are looking about a 4-month period, maybe a little bit under that, for the board to receive the advisory opinion from the hearing officer, evaluate it, and to render their final vote at that juncture, which would be the final step in the removal procedures process.
Thank you. I just wanted to ask, I understand that the sheriff's legal representatives were asked to provide feedback, and I want to know, and I want the public to know, did they provide that feedback by the deadline?
I think I've described the sort of the way that matters went down in the memorandum that accompanied this item. We, as we told the board we would, did outreach to the attorneys representing the sheriff, and we actually had a meeting on April 16th. At the time, I think it's fair to say that aside from a matter that I think we already had under advisement, we hadn't heard anything additional. And we did share that because of the agenda timelines we're on, we needed feedback by early in the week of, I want to say April 21st. And we did not, in fact, receive it on the timeline that we had asked. But we did, in fact, receive some feedback, and we included that feedback in the board packet. And we frankly didn't think there was anything additional in there that warranted further adjustment to the procedures. But again, you've received the feedback that we received.
Thank you. So it was not received in a timely manner. Is that right?
It certainly wasn't received on the timeline that we requested. I think that's what I'd say.
Thank you. And in terms of who has been identified as a potential candidate to be the hearing officer, can you talk a little bit about that?
The candidates for the role of hearing officer, I think I'd want to defer to Mr. Estrada on that. I believe that there are, ultimately what we're looking for are people who are skilled, knowledgeable about the peace officer, disciplinary process. It seemed that was a natural, given the context and given sort of the framework that we've put together. I don't know that we've settled finally on anybody in particular. Obviously, in fact, the procedures provide for an opportunity for choosing among a range of people. But again, the general criteria are folks who are deeply experienced in sort of law enforcement disciplinary matters. But aside from that, I guess I defer to Mr. Estrada.
So the criteria really that we looked at in considering who would serve as hearing officers are the foremost experts in public safety officer discipline in the state of California. Very experienced individuals who are well-versed in the issues that arise in this area of the law. And those are the folks, essentially, who we only considered to serve as hearing officers over a potential removal hearing. So a significant expertise in that area.
Thank you.
Great.
Mr. President?
Before we do that, Supervisor Spear, Supervisor Bueller, do you have any questions? Okay. Supervisor Spear, go ahead.
Mr. Estrada, does that mean that I was under the impression that we were going to be looking at retired judges?
No, the folks who are to potentially serve as hearing officers are arbitrators with decades of experience handling public safety disciplinary matters. Their backgrounds are specifically targeted, or we targeted individuals with that significant expertise in doing these matters. So no, it's not retired judges. These are extensively trained and experienced arbitrators who know POVAR, public safety discipline, back and front.
So are they lawyers?
No, they may have been at some point, but the vast majority of them are just practicing arbitrators / hearing officers who preside over these roles for decades. They have a ton of experience in the specific area. You'd probably be hard pressed to find judges with that level of experience specific to POVAR and public safety discipline.
And this is we are not taking action today to determine that, or is that incorporated in these procedures that we are taking action on today?
No, these procedures are just the rules, right, Supervisor? Just for how this is going to proceed from beginning to end. The hearing officer list will be ultimately finalized closer in time to when that selection would take place. And another prophylactic measure there, Supervisor Spear, just so you know, is that the parties get to meet and confer and strike from the list that we provide them to get to one, or they can come to mutual agreement as to who they will have preside over it. So again, there, another added layer of protection for both of the parties.
So the sheriff would be in a decision-making role as to who would preside over this final hearing with sworn testimony.
I wouldn't say a decision-making role, but she's part of the decision-making process. In that she'll, get to rank which of them she prefers, and then they meet and strike, and then ultimately one hearing officer comes out of that.
Okay, thank you.
Great. Any additional questions? John, I have several. What's before us today is the board adopting the revised removal procedures as the procedures for conducting a removal proceeding of an elected sheriff pursuant to section 412.5 of the San Mateo County Charter. Is that correct?
Yes, Mr. President, it is.
Great. And when we talk about revisions, you outlined them. Can you speak to Chief Probation Officer Keene's background, as well as the direction the board had provided to you relative to, the Chief Probation Officer? And then what I'd like you to do is then go to the county coroner. Sure. And then if you can run us through that. Yeah.
And actually, maybe I'll start with the second thing first, and that was, at the time that we were last here, one of the concerns was, as you know, when we brought you the draft procedures in their original state, or at least the original state, you all saw them in a public setting. It was, we had the the assistant county executive as the in that role, and a concern was expressed that the idea is to create as much independence and as much from outside looking in, fairness as possible to the process. And it was expressed that it would make sense to have somebody who didn't report directly to the county executive. And it was also, frankly, expressed that it would be probably optimal to have somebody who maybe wasn't even appointed by the board in the first instance. And Chief Keene fit that bill well. Chief Keene is actually appointed by and serves at the pleasure of the courts, which are separate and distinct governance-wise.
John, that's an important distinction.
Yes.
I think, one of my concerns, and I think my colleagues shared the concerns, was this issue that it was coming out of the county executive's office. And I think, to me, in moving forward, the independence of who over these proceedings is extraordinarily important. And so I want the public to know that as chair of this board, I think the board as well, take this very, very seriously. And so if you can continue, Mr. Niblin.
Thank you. Well, we heard your point on that, Mr. President. Again, we, and I think it was actually discussed at the time of the last meeting that Chief Keene might be an appropriate person for us to reach out to. And Chief Keene has expressed a willingness to be involved in the process in the way that it's being proposed. And so also, along those lines, recognizing that we need to plan for contingencies, Chief Keene, for whatever reason, if he was rendered unavailable, what would we do? We wouldn't want the process to stop. And it seemed to us that the next, appropriate thing for us to do in terms of making sure that we have somebody who is available to serve in that role if Chief Keene weren't able to, was to look at elected officials who have a somewhat different relationship to the county executive, and frankly, a slightly different relationship to the board, recognizing the board's got oversight responsibility with respect to the entirety of the county. There are, with respect to elected officials, there's a different dynamic, and so we had identified
If I could interrupt you, I'm sorry.
Yes.
So the county coroner, that's an elected position,
It
correct?
is. Under San Mateo County's charter, the county coroner is an elected position. Yeah. And one of the thoughts that, I was having was that, the coroner also does have a familiarity with the law enforcement context. And it struck us as, me in thinking about it with the team, that the coroner would be an appropriate backup to Chief Keene. I wanted to maybe perhaps get to your first question. That is, Chief Keene actually is, to my knowledge, I've had an opportunity to meet him a number of times over the course of my work here. He's actually a lawyer, has been to law school. I don't know if he's currently a practicing lawyer, but he's got legal education. He has served as a peace officer. I believe he served as as a patrolman back in I think it was Louisiana. I might be wrong about that, but a long history of law enforcement experience here in California as well. So certainly well versed in the context that is relevant here. So I guess that's how I would respond to your questions.
Great. And so my understanding is, just by the way of background, and Chief Keene served as the deputy probation officer in Alameda County. My understanding, and maybe it's Louisiana, I thought he was a police officer in Oakland. I think maybe it is Louisiana. And then how long has he served in the position with the county? I saw online maybe 2013. Does that sound?
I was going to say over a decade. So 2013 strikes me as the right year, likely, but well over a decade.
Great. And then can you speak a little bit to Robert Folcroft, the coroner, and his background, just so the public knows?
And again, Mr. Folcroft has served as the county coroner for many, many years, probably over a decade, probably longer than Chief Keene has been in his position. The nature of the position is one where it involves a lot of interaction with law enforcement. And I think even before becoming the elected coroner, I believe that Mr. Folcroft served in the coroner's office. Some of the details of that are fuzzy to me, but again, I know he's got long experience in this area. And again, I think that the context is related enough that it provides a good background for the responsibility he would be asked to discharge under the procedures if it came to that.
In my understanding, like Chief Keene, he served I believe he served with the San Bruno Police Department in some capacity.
Yeah, I believe that's true. I believe
Great.
that's
Yeah,
true.
and I do think there was a paradigm shift, right? The paradigm shift was the person that was suggested that it was going to come from the county executive's office, and then what we've been able to do is to identify two candidates that, to be quite frank, are independent, right? So one is appointed by the judiciary, and the second is directly elected coroner. Both of them have law enforcement experience previous to their roles here with the county. Is that correct?
Yes, it is, Mr. President. And I would say I appreciate your kind of validation that we responded effectively to the concerns the board raised when we were last here. I think that this is it's a good change. Frankly, it's one that the Sheriff's Council raised as well. So I believe this is an appropriate thing for us to have done. And I think for all the reasons you've already touched on, I think these are appropriate folks to discharge this responsibility if in fact they're called upon to do so.
Great. And then in regards to the initiation process, and I just want to continually reinforce this, that is not happening today. We are looking at sort of the protocols, the procedures, and the revisions that were made. Is that correct?
That's correct, Mr. President. The initiation through the approval of a notice of intent would be for another day. That is not something that's happening today. Today, the board is being asked to approve the procedures as we've amended them to address concerns since the last time you had a chance to look at them in a meeting.
Great. And let me just say this. I know to the general public, there are some out there who really want to move fast on this. And make no mistake about it, I'm not interested in how fast we're moving. I'm interested in affording the sheriff due process, being thoughtful, being deliberative. And finally, let me just say this. What we're doing today is the first time that this has ever been done in the United States and the state of California. And I don't think it's lost upon my colleagues or myself how important this is. And so what I would say in terms of, we're giving timelines and doing those sort of things, to be quite frank with you, I'm not interested in timelines. I'm interested in making sure that we have a fair impartial, just process. And as chair of this board, make no mistake about it, I'm committed to doing that, and I think this board is as well. Are there any additional comments? Seeing none,
Mr. President, are we going to hear from the sheriff or from her attorneys today?
what I'd like to do first is I'd like to hear public comment first. Once I hear public comment first, then Supervisor Spear, I'm the chair, respectfully. So what I'd like to do is to hear from the public first, and then if the sheriff would like to speak, she will have the opportunity to do so. So out of respect for the public, I'd like to hear public comment right now here in the chamber, and then thereafter, what we'll do is we'll hear it online. Thank you.
Thank you, Mr. President. The comments are for item number 11. If you wish to speak, the speaker slips are outside of chambers, so please fill the green speaker slip and give that to me. I have so far 6 speakers from chambers, and then we'll hear speakers from Zoom. I'll start with Dan Stegging, followed by Matthew Fronfeld.
Good afternoon, Supervisors. My name is Dan Stegging. In 2018, I ran against former Sheriff Horsley for this very board here. I've written more Democratic state resolutions on criminal justice reform than anyone else in San Mateo County, Santa Clara County, and San Francisco County combined as a previous state Dem delegate. With all due respect to the board, John Keene is not a licensed attorney in the state of California, and being Louisiana police have some of the highest rates of malfeasance in the United States. Also, County Coroner, Will, a nice guy, has no graduate degree, has no undergraduate degree, and I believe is not a high school graduate. Alfonso is, I believe, from the court documents, is the 3rd law firm that the county has been represented since November. I urge you strongly to take a look at the Strunsky report by retired Judge Strunsky, which is completely indicting of the Cordell report. And in the last 2 seconds, I'll say it focuses, the Strunsky report says that report focuses solely on a single witness testimony that has not been collaborated by another investigator, recorded, and is anonymous. Thank you.
Thank you,
Thank you.
Mr. Stegnick.
Our next speaker is Matthew Frenfeld, followed by Thomas Mizuko. And please adhere to the 1 minute. Thank you.
Good morning, members of the Board of Supervisors. I'm one of Sheriff Christina Corpus's attorneys, so thank you for this opportunity. And you're right, Supervisor Canepa, due process does not require speed. With reference to our recommendations and our notes regarding the proposed rules from
Could you speak into the mic, please?
the third, or there's 4 firms that have been involved in representing the county. This is complex. County Council, now there's 3 additional firms. And we submitted, there is no legal authority for the county to determine that we should have something by the 21st. You have it in your packet. You should have read it. You got it, received it on April 29th with our objections and suggestions. Now, you cannot vote today on this if you have not read that, because that's part of what's attached to your document for the Board of Supervisors today. So what did we recommend? Well, we recommended, for example, there was a letter from the Kecker firm, your 3rd law firm involved, saying that the hearing should be open the 1st level. Well, thank you, Mr. Estrada clarified that that's not the county's prerogative. That is the prerogative of the sheriff under her POBAR rights, the government code, and the California Penal Code. Secondly, there's a mention about timing, 5 days here, 5 days there. That's arbitrary. We're representing the sheriff who ran for this office and overwhelmingly won this office due to the other sheriffs. Then I hear from the people here saying, well, Measure A passed and it was, 80% of the vote. I got to tell you, you're delusional. 20% of the registered voters participated in that. An uncontested ballot measure, single measure on the ballot. So I wouldn't take that to the bank. Secondly, with reference to all this was done because you were misled. You were sold a bill of goods by the Cordell report. I do suggest you read the Judge Strunsky report. Her report is fatally flawed, lacks zero evidentiary value. Our other concern, and it's been expressed, and thank you, there's concern about bias. And there's concern openly here about the county administrator or his subordinates be involved in any of this process. You recognize that. Well, he's not alone. Not alone. You look at what we recommended. Measure A in your disciplinary process has been defeated by the own words of members of this board. The bias. Now, Mr. Estrada hit the nail on the head when he was asked by Supervisor Spire, are we acting in a quasi-judicial capacity? He was 100% wrong that you weren't. You are. That question was asked, or that was answered, because a judge has already questioned that in some of our pleadings with one of your first firms about the bias of the board and how can you get to 4/5 vote when members of this board have openly said the sheriff should be removed. You can't do it. That's bias. In fact, I just saw Saturday in the paper, Mr. Simon, who everybody seems to be a gossip columnist here, Mark Simon, he said that all but one member of the board have already said that the sheriff has to go. You are recused. You can't make this vote. By operation of law, you cannot. And we will bring that to the courts. Secondly, about who could be the hearing officer. We recommend it's not somebody from the San Mateo County family. Yes, you tried to stretch the independence of who these other people are. The medical examiner, the chief probation officer. Supervisor Spire is right. It has to be a retired judge. We suggest a retired judge who has familiarity with the law, POBAR, and there are people, judges who are police officers who know POBAR well that are retired at JAMS and at ADR. I think that's the correct route to go if we get there. But the truth of the matter is this board is an echo chamber. You cannot be the prosecutor, you cannot be the judge, and you cannot be the executioner. You lost that right in your statements to the press. And with reference to this being a quasi-judicial capacity, I will submit to you for 12 plus years I served as a San Francisco Police Commissioner on the Police Commission doing disciplinary proceedings, whether or not we were going to discipline an officer or fire an officer, and the courts have clearly held we were in a quasi-judicial capacity. The court earlier ruled that you were not in a quasi-judicial capacity when you set this as a legislative measure to the voters. But once you start getting into the facts, you're acting in a quasi-judicial capacity, and you'll see the case law says you're clearly
Mr. Mizuko,
forbidden from doing that.
I'm going to allow you to continue to 5 minutes.
Thank you.
Let me just ask you this: is the sheriff? You're representing her, or is she willing to speak today?
I'm representing her today, yes.
Okay, and the sheriff is not going to speak. You're her counsel, correct?
I am her counsel, yes, along with two other counsel that are present today. We brought two counsel with us because we thought we were going to be restricted to the 1 minute.
Okay. Do you? What I'm going to do is I'm going to give you. I'm going to give you to about the 6 minute mark.
Okay.
And that'll wrap up your comments. Okay. So go ahead.
So thank you. So again, we don't think you can even get there. You can't get to where you want to go to even have these votes come from these hearings before this board. You can't. Secondly, if you do, the rules should give us the time that we need, the evidence that we need, because the sheriff's entitled to due process. And we're also concerned there's issues of everything that the sheriff does is considered retaliation. And running a sheriff's department, a sheriff's office, you have disciplinary matters. They come to you all the time. We'll have an expert from a police department saying it happens all the time. Deputies get in trouble. If the sheriff moves to protect the public from bad deputies, that's not retaliation. Also, we have to address the issue of, we'd like to talk about some of these retaliation claims, but those deputies have POBAR rights too. And they're going to have to waive them. And I'm sure some of them do not want public what they did wrong that they can openly say is retaliation. Sheriff's more than willing to talk about that. But our concern is bias and prejudice. And it starts at the very top with whoever. This county will not tell us who requested the Cordell report, the context of the Cordell report. We are now suing the county on behalf of the sheriff to find out what that's all about. And I really think you have to look at the Judge Strunsky report. That Cordell report is terrible. There's no recorded statements. There's no names of witnesses. There's no notice of what bias. Who brought them on board? Who brought her on board? Who asked her to do this? Who did that? Was there an intent? Why was this end around on the voters by doing a ballot measure?
If we can wrap up.
A ballot measure only on the election? The single thing, a measure to remove her? There's confusion. I just saw it here now. Like, was it to remove her? Was it a recall? Nobody really knows what's going on. It's complex. You've had several law firms involved, but I'll tell you, justice and due process should not be rushed, and we're not, and this board cannot make that decision.
Thank you very much. You know, to the general public, I typically, you know, as you know, we have a minute. Sometimes it goes to 2 minutes. But I do think in this particular case, I think we allowed you to speak, Mr. Mizuko, through the clerk. Was it 6 minutes?
That's correct.
Through 6 minutes. And I think the reason I did that, and you're right, Supervisor Corzo, as the chair I did that, is I think it's important to hear in light of, you know, the sheriff. And so I want the public to know as we move forward, you know, our main goal is to be fair, to be transparent, and follow due process. So I appreciate you making those comments. We do have a couple questions. Supervisor Spear.
Thank you, Mr. President. You questioned the amount of time you would have in order to prepare for the hearing that would take place by the hearing officer. How much time are you requesting?
Supervisor Spear, we don't even know what the allegations are. So how can we prepare? We have no idea what the allegations are. There was the Cordell report that had a lot of allegations, which the time has lapsed on. There's a lot of issues with those allegations. And now there's a new independent investigation being conducted at the county's behest, where they're actually, as we speak, interviewing other witnesses. We do not know what the charges are. So I can't tell you how long it would take to prepare.
And do you object to having, who would you prefer to have as a POBAR hearing officer?
A retired judge, and not somebody from the county family.
And who would you prefer to be the hearing officer for the more expansive hearing that would take place if the sheriff would appeal the decision?
Also, either a retired judge or an attorney who is familiar with POBAR proceedings.
I'm sorry, I just want to jump in and, like, this is public comment, so we're not really
Well,
supposed to be having back and forth dialogues. And I just want to state that for the record.
Colleagues, I really want to be respectful of this process. I think Supervisor Spear is entitled, as many of us on the board, to ask questions. And so we're going to continue. A few other board members want questions or have comments at this time. It's the best time to answer. Supervisor Spear.
Well, I think for the record, this is a very important process. The representatives of the sheriff should be allowed to participate in that process and indicate their interest in how it's going to move forward. It probably shouldn't be under public comment. It should have been part of their presentation, but that's where we are. And I think you've been given, I think, ample time to make your comments. Is that correct?
Yes, Supervisor Spear.
Thank you.
Thank you so much for that, and thank you, Supervisor Canepa.
Thank you very
Greatly
much.
appreciate it.
Okay. So I think you're done.
Okay, thank you.
Respectfully.
It's
Okay.
not the first time I've been told that.
Okay, thank you.
Thank you so much.
With that, we'll move to public comment.
And
We're in public comment, but next speaker, please.
Matthew Frenfeld, are you speaking? And Mr. President, 1 minute. Is that correct?
Matthew, we're gonna give you 30 seconds. You're with the council. You're with council, correct?
I am. Thank
Okay,
you. Yeah,
thank
that's
you.
okay. Tip is more eloquent than I am.
Thank you.
Good morning, supervisors. I'll be very quick here. There's serious legal issues with the proposed removal proceedings. I think, Mr. President, you nailed it. We all want to get this right. It's important to get this right, because if we go through this process and it doesn't follow the requirements of due process and the law, it's going to extend longer. It's going to be extended out through litigation and cost more for the county. There are issues with finding a neutral finder of fact here. The board has made public statements that shows they have prejudged this issue, and it needs to be recused. Thank you.
Thank you. Our next speaker is Mariah Cooks, followed by James Brown.
Good morning. Mariah Cooks, I'm also acting as counsel for the sheriff.
30
today.
seconds, please.
Thank you. What I'm really here to stress today and what I've heard from the supervisors is the importance of this being fair. Yes, thank you. Of being fair, impartial, and to really satisfy the elements of this being due process. The process that has been outlined today is outlined as being linear, but really it's circular. As the board, you're acting as the accuser and the adjudicator. You're making the decision, and all the way up through appeal, where you're rubber stamping the accusation, the decision that was made. Having an independent investigator or
You
reviewer.
can wrap up.
Yes, thank you. I was a DA at the start of my career. Probation submitted reports to the judge. There was often times that report was not followed by the judge.
Thank you, Mariah.
Thank you.
Thank you.
Appreciate you.
Next speaker, please.
Thank you. Next speaker is James Brown.
Mr. Brown, are you public or are you the counsel with the
I'm a
sheriff?
member of the public who's also a firsthand witness to some of the information in the Cordell report.
Okay.
So good morning, supervisors. My name is James Brown. I'm a resident and business owner in San Mateo County. I'm a disabled Marine Corps veteran, and I manage 2 nonprofits, one of which operates here in the county. I know Sheriff Corpus as well as the captains who oppose her. I've been a contractor for the Sheriff's Office under the last 4 Sheriff's administrations. However, I now have serious concerns, and I have 2 direct questions. Why have I, a member of the public, received media inquiries suggesting that I or my firm are mentioned in the 29 missing pages of the Cordell report? And number 2, why have I received media inquiries about emails that were sent by County Executive Mike Callaghan to the FBI that reference me or my firm when I am not the subject of any investigation at any level? Both matters relate to the lease and the services for the 690 Broadway facility, of which I do have direct firsthand knowledge. Yet I was never contacted by Judge Cordell or anyone else. Had I been, I would have testified that I am the person who introduced Mr. Anye to Mr. McSweeney. Mr. McSweeney, who is mentioned 18 times in the report, was also never contacted. I know because I sent him a copy of the report when it came out. His response to me in writing, which I'm happy to share with you at any time, is that report is a joke. I do not know Victor, and we are not Coldwell Banker. I am willing to testify under oath at any time, including right here, right now, about how and when that introduction occurred. So I ask you directly, do you want the real story from someone with firsthand knowledge, or are you content with the conjecture in the Cordell report? At the time of the introduction, Mr. McSweeney was accompanying a county employee with whom he had worked with on the lease. Members of the Sheriff's Office and the Sheriff's Activities League Board were invited to tour the site. Aside from the county employee, I was the only person there who knew Mr. McSweeney beforehand.
can wrap up.
CBRE had been my landlord for over 20 years and a client for the last 15. Thank you for your time. The last thing I'll just add on my way out is that the hearing officers that you suggested, all of them rely on you for their budget. All of them rely on you for your budget. That's hardly independent.
Thank you very much.
If you have questions, I'm happy to answer them.
Great. Thank you, sir. Next speaker.
Thank you, Mr. Brown. Last speaker from Chambers is Jim Lawrence. And then we'll take speakers from Zoom.
Good morning, supervisors. For the record, my name is Jim Lawrence. On behalf of Fixing San Mateo County and the many residents who've reached out regarding this growing regard of public safety, we respectfully urge you to adopt a resolution initiating procedures to remove Sheriff Corpus from office. This is not a position we take lightly, but when public safety is compromised, when trust is eroded, and when leadership fails to uphold the standards of our community, those expectations, and we deserve that, there must be changes made. The Sheriff's Office plays a critical role, leadership role, in ensuring justice, safety, and accountability throughout the county. Today, a void exists. Therefore, we're calling upon you to move as swiftly as possible, but decisively, and make this happen. I'd like to add that I live in Foster City. We had an incident where we lost one of our officers to suicide. I'm concerned about the officers in the sheriff's office also. There's a state of turmoil there that we need to deal with that. Thank you.
Thank you so much.
Thank you. Madam Clerk, please proceed with Zoom comments.
Thank you. At this time, we have five hands raised. Rhonda Reyna, followed by Paul Ryan. Rhonda, please unmute and begin.
I heard Mr. Estrada describing unconstitutional ADR procedures. Administrative contracts require consent by all parties. They are not judicial and violate Article 3 of the Constitution. The sheriff does not have to consent to this. She should learn her rights and study the unconstitutional Judicial Improvement Act of 1990, which was quietly implemented to a dupe public in an act of treason. This board is trying to run the family court playbook on the sheriff that so many of us have already suffered under. You are discussing the same unconstitutional private judging used in family court fraud without due process. I urge her not to consent to her own abuse or give up her guaranteed rights. The remedy is a recall. It would take less time and cost less money to the public, but you are trying to set an unconstitutional precedent. As one of the people of California, I object and do not consent to these violations of constitutional safeguards and this attempted act of treason by the board that will affect all of California and beyond. I urge you to strike and do not accept this resolution. You can run a recall. The public can run a recall if they wish.
May I have a last call for,
Thank you, Rhonda.
may I have a last call for speakers?
Sure, Mr. President. At this time, members of the public on Zoom, please raise your hand to speak for this item number 11, and I will announce the final name that we will take for public comment. Final call has been made, and the last 5 speakers are as follows. Okay, we now have 6 speakers. The last 6 are as follows: Paul Ryan, Michael Kelly, iPhone, Giselle Smeal, Thelma Uribe, and Mike Phillips is the last speaker. Paul Ryan, please unmute and begin.
Thank you. Yes. First off, express appreciation for naming the importance of due process in this whole proceeding. I think a lot of my concerns were answered, but I just wanted to double confirm that nothing in the Cordell report is eligible for grounds for removal retroactively. So my understanding as a member of the public, after hearing from everybody, is that the charges or the allegations rather that were raised in the Cordell report are ineligible for removal for the sheriff, and that you have to find new egregious behavior to start these proceedings. The other thing that just in response to another comment that was made publicly when it comes to public safety, also very concerned about that, and forcing the sheriff to have to deal with all of this on top of keeping the public safe is also a risk to public safety. She should be able to do her job. Thank you.
Thank you, Paul. Michael Kelly, please unmute and begin.
Good morning, supervisors. This is Michael Kelly. I'm a San Mateo business owner and community activist. I implore the 3 honorable supervisors that I've heard speak, President Canepa, Supervisor Spear, and I hope I'm getting right, Supervisor Gautier, to follow the money, because that's always where this comes from. When Sheriff Corpus turned off the spigot from the unions getting double overtime pay, from the privileges that were abused when we needed extra support in the jails, and sworn officers took advantage of that, made a lot of money. She turned that spigot off and the union came after her. So millions of extra dollars run up. Supervisor Corzo is taking funding from the union. Supervisor Mueller is, I believe, putting a bid in to become DA, and they're relying on money from the unions. Follow the money. Sheriff Corpus has filled the massive gap of new hires. She's got all these sworn officers. My son's best friend just became a sworn officer. She's doing her job. Let her, please. Vote against it. 2 of the 3 of you need to stand against the dishonest supervisors on this board. Thank you.
Thank you, Michael. iPhone, please unmute and begin.
Good morning. Can you hear me?
Yes, thank you.
Yeah, good morning. My name is Joaquin Jimenez. I'm the former mayor for the city of Half Moon Bay, a community activist for many years. And I am seriously concerned, and I'm actually embarrassed. Uh, this has been a biased process from day one. Unfortunately, a lot of our elected officials jumped on the bandwagon to a report that has no grounds for anything. It is embarrassing, that you did this as friendship, to support Supervisor Mueller and Supervisor Corso. I don't know what kind of politics you play. I don't know if you believe in democracy, but this is not it. No, you're embarrassing San Mateo County. You're embarrassing us who still believe in democracy. Who you said about precedent. Chair Canepa said, this is the first time happening in the United States, and you have to think about that. Putting San Mateo County on the map because of this process, it is embarrassing. Thank you.
Thank you, Joaquin. Giselle Smil, followed by Thelma Uribe. Giselle, please unmute and begin.
The law is not ambiguous. Quasi-judicial is a smokescreen. It's a legal fiction. If it's not a judicial act under Article 3 or a state's judicial branch, then it's not a court, period. Call it quasi doesn't give it power. It's exposed fraud. It's a clear violation of due process of law.
Thank you. Is that the end of your comment?
Yes.
Okay, thank you. Thelma Uribe, please unmute and begin. Thelma, you are unmuted, please. We don't hear
Hello.
you.
Can you hear me?
Thank you. Please go ahead.
Hello.
Yes,
Can you hear me? Are you hearing me?
yes, thank you.
Okay.
Yes, we
Thank
can
you
hear
very much. First, I want to thank Canepa for offering fairness. This Board of Supervisors is biased. It has been, especially with Corso and Mueller. From the beginning, Corso came out there like a bull and was just telling the sheriff, talking about her so bad. She's not given, the Cordell report was extremely flawed and calculated to a bit of piece, riddled with tons of misinformation and hearsay, especially employee number 3. She was a disgruntled, or she is a disgruntled employee. When she did not get the promotion she wanted, she thought she deserved, she turned on her. And there is somebody that put it out there publicly that he will talk under oath to report that. Now, the judge strongly, which reveals the problems and lack of evidence within the entire report, I think it's true. The Cordell report is the fruit of the poisonous tree. Now, also, I just want to say that this appears that to be an orchestrated effort by Mike Callaghan, the unions, Ray Mueller, Nolia Corso, and this is not democracy.
Thank you, Thelma. Giselle Smil, followed by our last speaker, Mike. Giselle, please unmute and begin.
We just heard from Giselle, Madam Clerk.
Oh, my apologies.
Sorry.
Let's go to Mike Phillips. Please unmute and begin.
All right, good morning. I keep hearing people call them well-versed administrator judges, but here's the truth. They don't sign orders under judicial capacity. That means every order issued is a denial of due process. No oath, no authority, no law. You could cite case law, Carper versus Fitzgerald, 1887. A judge is not the court, and when they act outside their judicial capacity, like signing ADR orders, they are not exercising lawful authority. They're acting as private arbitrators. That's not due process. That's impersonation of a court. Thank you.
Thank you. Mr. President, back to you.
Great, thank you very much. I want to thank the public online and in the chambers for their comments. What is the pleasure of the board? Are there any comments? Supervisor Spear.
Thank you, Mr. President. I have for some time felt that we needed retired judges participating in this process. After hearing Mr. Estrada today say that even the third more enhanced hearing is going to be by someone very informed about POBAR, but not a retired judge, it's really given me reason to pause. So my question to you, Mr. Neblin, is are we at a point where we can still amend this procedure?
Board hasn't acted on it yet. The board can, of course, amend it in any way it chooses to. I would note that Mr. Estrada had, well, let me just stop there for a moment. Yes, of course, you can make changes that you deem appropriate. The board hasn't yet acted to adopt these procedures.
Supervisor Spear, my memory of Mr. Estrada's comment in that area was that there be future actions to actually appoint who that hearing officer is. I, when you're questioning, heard the same thing and thought, well, we can take care of that at the time the board actually moves to, if the board gets to that point, moves to appoint the hearing officer.
I want to clarify though, Supervisor Mueller, I don't think it, and Mr. Estrada can correct me, I don't think the intent necessarily, if the board approves these procedures, I don't think the intent was that the actual appointment of hearing officers would need to come back to the board. That would be something that would happen in a process that would not, again, necessarily require board action. What Mr. Estrada had noted is that there are a number of extremely skilled and experienced people in the state of California who are not retired judges, frankly, are probably better qualified than most retired judges to deal with these kinds of matters because that is their job as they deal with them day in and day out. So it was our recommendation that we, sort of look in that direction. I think Mr. Estrada had noted that, we would not in the ordinary course expect them necessarily to be retired judges, but again, it's up to the board to decide if they want to make adjustments at this point.
My apologies, Supervisor Spear.
That's all right. So I feel strongly that we should have a retired judge in the POBAR hearing, in addition to a retired judge or group of judges at the final, more expansive hearing. So I would like to offer that as an amendment to these procedures.
All right. So, Ms. Spear, are you making a motion, or are you just?
Yes. If you want further, I am persuaded that the person who should review the POBAR hearing of the sheriff should be a retired judge and not the probation officer.
I guess what I would say to that, Supervisor Spear, is that, again, we will revise this pursuant to the will of the board. Again, we were trying to track the ordinary, we were trying to track the POBAR process, and that typically contemplates that you would have somebody internal to a police department. If we were going to use the analogy, you'd have the assistant chief, for example, be we'll call it to use the term we're using, the POBAR officer, the pre-decisional officer. So it would be unusual in that context, frankly, to have an outside judge, for example, sit in that role. So I'd note that would be something that would deviate, frankly, from the ordinary POBAR process. I don't know if Mr. Estrada maybe wants to speak to that.
Yeah, I wholeheartedly agree with the county attorney on that point. I've handled hundreds of peace officer disciplinary matters throughout my career. Not once have I ever, at the pre-removal conference, had any of those cases where a retired judge presided over it and not somebody actually from the county or city. And then just separately, same goes for the hundreds of disciplinary appeals I've also handled in the public safety realm. Again, not once have I had a superior court or retired judge of any sort preside over those matters. Both unions and employers want the experts in the area, and the experts in POBAR are very clearly the folks who handled the disciplinary appeals of peace officers in the state of California, have done so for some time, and really have created the substantive law in the area.
Supervisor Canepa, I apologize. Normally, I would just get up and excuse myself from the room, but I don't think that's appropriate in this hearing, and I do need to excuse myself from the room. So could we have just a 5-minute break?
Sure. What we're going to do right now is we're going to have a 5-minute break. We'll be back in 5 minutes.
Mr. President, the time is now 10:46 a.m. We're back in open session. For the record, all supervisors are present. Please proceed, Mr. President.
Great. Thank you very much. Supervisor Corzo.
Thank you, President Canepa. This process is extremely detailed and well thought out. I appreciate the County Attorney's Office and Mr. Estrada for all of the thought and conversation that went into clarifying details. This board does all of its discussion and decision-making in public, and it's available for the public to review as far back as when all of this began. And I want to recognize that this is unprecedented, as President Canepa said previously, which makes this level of detail even more important. I have hope that no other county has a need to adopt procedures like the ones before us, but if they do, they will look to San Mateo County for precedent on this matter. I'm prepared to accept this process as proposed, and I want the public to know that 90,900 voters in this county entrusted this board to do so. Thank you, and I move to approve the procedures as presented.
Great. Thank you very much. There is a motion on the table.
A second.
Great. Supervisor Spear? Do you have any comments?
Well, I've indicated my interest in wanting to see a retired judge participate in this process. And I think I'm going to just leave it at that.
Great. Colleagues, I'm not adverse to having a retired judge as well involved in this process. I don't know where the board, if there are any, where the board may lie on this issue. I'll open it up, but I do think Supervisor Spear brings up a different idea, an idea that I think is sensible. Are there any comments from colleagues?
So my only comment on this issue is the issue of qualification. And so I feel, so at first glance, hearing retired judge makes sense. But if there's a lack of qualified retired judges experienced in POBAR, then it becomes more difficult to try to find someone for scheduling and whatnot. So, but what I would be interested in doing is what I thought the original plan was, and that would be that we would adopt the procedures today and then revisit the qualifications, because what I would think would be interesting and important to know from a relevance perspective is to hear back from council as to whether or not there are qualified judges with the same level of qualification for this process. If that council comes back and says there are not, then that would potentially inform this board as to what to do. If they came back and said, yes, of course, we can do that, that would inform the board what to do.
County Council.
Mr. President, thank you. And Supervisor Mueller, I want to kind of check my understanding of kind of what's been suggested, and that is that we'd be looking at perhaps a tweak to the procedures that would mandate that county staff would come back to the board prior to assuming we reach the stage, prior to the actual preparation or finalization of a list of hearing officers, so the board had the opportunity to see, and I guess in a public setting, who was on the list of potential hearing officers, so that before they're submitted to the sheriff for consideration. Again, assuming you reach that stage. Is that what I'm understanding?
No, I mean, I respect actually that within the process, the board wasn't going to select these individuals. But I think what would be important to have to come back to the board at a later date would be whether or not there were requisite qualifications the board was interested in. So the board, certainly there are members of the board who are interested in there being a judge. And so whether or not we are advised by council publicly whether or not there are qualified judges to do this process. And so I think not, I don't want the board, I personally would not want the board to identify that individual, but I would like the board to look at the qualifications of individuals. Does that make sense? So it's almost blind. You're just looking at qualifications and you say these qualifications are the qualifications that this board thinks will result in due process, but not actual individuals.
What I would note is that the procedures themselves mandate, and I'm hoping Alfonso can point me to the exact place, generally speaking, that anybody who would be proposed to serve as a hearing officer has to have experience in public safety discipline matters. And I think that's roughly quoting from the procedures. Mr. Estrada, could you confirm that?
Yes, it is embedded right into the procedures. I'm looking for it now. Hearing officer list, section 2. One moment.
Gentlemen, I am trying very as well as I can to reach a compromise between the concerns of my colleagues and the procedures as they currently stand.
Right. Right.
Is there some reason why that there would be difficulty with in a report back with respect to the qualifications of the list?
Again, there's no problem with anything the board ultimately wants to include. I just want to be clear on, is that if we're reporting back, are we waiting for board authority to proceed with folks who are on the list? I guess I'm just a little unclear on what the list would.
Can I just jump in here? I want to call for a point of order. We have a motion and a second on the floor, and the motion that was made previously did not receive a second. So I feel like we're at a point where we need to take a vote. And I understand the compromise that Supervisor Mueller is suggesting, and I think the procedures as written allow for that. And I haven't heard anything different.
Well, I want to be fair to Supervisor Spear. I interjected before saying I need to use the restroom before there could be a second. So I took your motion actually as a substitute motion because you were called on before that happened, before there was a question from the president whether there was a second. But so the way I see it is there's a substitute motion on the table. There was never actually an opportunity to second Supervisor Spear's motion. Regardless, I'm trying to figure out a way that I can get all of us on board. I think it's important that this vote be unanimous by the board moving forward.
Mr. President, again, I just wanted to clarify, and bear with me, maybe I just am kind of missing the point. What exactly would it be that staff is being asked to bring back? Just so I'm crystal clear on it.
Go ahead.
Well, I think what would be important is hearing from my colleagues is that they want to see whether or not there are qualifications, including judges, who would have the requisite experience so they could go ahead and look at a list of individuals, not by name or identifying information, just the experience and qualifications of the individuals on the list.
Through County Council, let me interject. Supervisor Mueller, and I want to speak for you on this item. Is that something that you want to include in the motion, or is that something that runs separate? And I think what I'm hearing from County Attorney Niblin is that within the existing procedures and protocol, it's pretty specific on who can fill that role. Is that correct, Mr. Niblin?
Yes, I would want to note that.
John, can I just give the reference to the specific provision? So the specific provision and the procedures as currently constituted is in section I, Roman numeral 1, subsection 4, subdivision 6, and it calls that the hearing officers that will be proposed in the list have experience in public safety officer disciplinary matters, available to timely preside over the removal hearing. So that is the language as to the requirements. And it certainly does call for experience in public safety officer disciplinary matters.
So I'm going to confess this is breaking down because I was hoping for more of a discussion and it seems to be becoming very procedural around votes. So I'm trying to actually have a discussion with my colleagues about how we can move this forward.
Mr. President,
Supervisor Spear.
you know, I think there is a conflict between this interest in wanting to make sure that the initial hearing officer has experience with police efforts or police discipline, whereas we have already set forward what the 4 conditions or 5 conditions are. That's what the voters passed. They passed a measure that gave us the authority to remove the sheriff if there was a showing of violating the law and performance of duties, in neglect of the sheriff's duties, in misappropriation of public funds, in falsification of statements or documents, or obstruction of law to of a sheriff in an investigation into the conduct of a sheriff. So those are the bases on which the voters decided that we would be empowered to terminate the sheriff. Now we're saying that separate and distinct, we're having this hearing in POBAR, which requires having someone who has been involved in disciplining law enforcement. Regardless of that, we still have these 4 or 5 elements, and I don't think you need to be a disciplinarian or someone who has had hearings on POBAR in order to make a finding of this. So I guess I just disagree.
So Supervisor Spear, can I ask because looking at the specific amendment, specific language, if we added to that language with a preference for a judge if qualifications are equal to other qualifications and background, would that satisfy your concern?
It would.
Then I would go ahead and move that forward. So that would allow us to say if they can't locate a judge with that same level of qualification, and you bet that's going to be something that's going to be fought about with opposing counsel. But that's, if they can't, they can't. But if they can, there's a preference of the board that it be so. Are my colleagues in agreement with that? Okay, so let's go ahead then and add that as an amendment. And let's ask Mr. Estrada, is there a problem with that, sir?
My position remains unchanged as far as the benefit of a judicial officer presiding over this type of disciplinary procedure. Judicial officers only really get public safety discipline cases when they go to them on a writ after the fact. It's a very small slice of what sitting judges actually deal with on their docket. So,
well, you will be charged with finding one that with who may have those equal qualifications if you can via this motion.
If they exist, I will endeavor to do so.
Thank you, sir. So I will go ahead and move to add that as a friendly amendment to the motion.
So we need
For a second.
We need the maker of the motion to make that amendment. Yes.
Will you accept that motion, Supervisor Corso?
Before I answer that, I just want to state that the motion that I made, I heard Supervisor Spear's concerns and suggestions, and my understanding of how the procedures are written is that wouldn't be excluded. So I do accept the amendment.
Great, you do. Wonderful. So there's a motion. There's a second.
Thank you, Supervisor Gaucher.
By Gaucher, may I have a roll call, please?
You accept that, right, Supervisor Gaucher? Okay, thank you. I'll take the motion. Supervisor Spear? Thank you. Supervisor Corzo?
Yes.
Thank you, Supervisor Mueller?
Yes.
Thank you, Supervisor Gaucher?
Yes.
And President Canepa?
Yes.
Thank you. Motion passes unanimously.
Thank you very much, and thank you to the public, okay? Thank you.